If you've been turning the dial on your television set looking for a public service broadcast on something to do with sheep diseases or all that you ever wanted to know about the spleen or pancreas, this is not the program. This is a program devoted to subjects dealing with crime in America. In this segment and in the one following this, we will be talking specifically about the courts, the court structure, procedures of the court process, and some problems dealing with the courts. Now, in prior segments, we've discussed some already, and we will be rehashing a couple, but we're going to be bringing you a lot of new material. Now, if some of you, not many of you I'm sure, but if some of you out there have ever been to court for some reason, you may remember how nervous you were perhaps, or how confused you were the first time you went into court and sat there. And there's a little feeling of anxiety perhaps that builds up. And if this has happened to you, you can appreciate the feelings of those in our viewer audience who have never experienced this before. It can be a very unnerving procedure, and with some it can be almost a paralyzing experience. Now, we're going to try to defang the monster somewhat, and that we're going to try to tell you in this segment and in the next segment something about how the courts work for those of you that don't know how the courts work. Now, sometimes in a viewing area, we're piped in through television to people who may be temporarily in custody and who may be watching this particular program, and they probably could do a guest lecture job as well as I could. But if they will just nod once in a while in agreement, I'd appreciate it. Now, there are a couple of items to keep in mind as we review some of these things and as we present new materials. And the first thing that I'd like to talk to you about is a term that's used quite often in the courts and about the courts, and that term is jurisdiction, and we'll show it to you on the screen. Now, jurisdiction simply means the authority of a court to hear a case. It refers to a number of things, but it means the authority for a particular court to hear a specific case. Now, jurisdiction can deal, for example, with criminal law subject matter. That is, for example, it is a civil case or it is a criminal case. And you may be in a large metropolitan area where they have more than one court, judge hearing cases. There will be a civil division, there will be a criminal division. Subject matter. Remember that we told you quite early that a civil problem or a civil litigation is usually referred to as a tort, T-O-R-T. So the subject matter jurisdiction of a tort would be in the civil division or civil sessions. The subject matter of crime would be in a criminal division. Now, you also have geographic considerations when you're referring to jurisdiction. That is, as we are broken, our country is broken into geopolitical areas such as states, counties, cities, and so forth. The courts usually will have the same kinds of parameters or boundaries. That is, a state court in one particular area would hear cases that occur within its state and not some others. It may, once in a while, you may have had a situation like that, but generally speaking, no. It will be handled in a particular state, and then it will be handled in a particular geographic boundary of a particular court. If the offense occurs within the jurisdiction, the geographic jurisdiction of the court, it will be the original jurisdiction or place of the trial will be in a court within the boundaries. You also may have a situation where you have state versus federal. Now remember that each one of us has dual citizenship in that we are responsible for state laws, but we also are responsible to adhere to federal laws. We have state protection through state constitutional rights, but also we have federal constitutional rights. And you may commit an offense which violates a federal law, and you will be, then the original jurisdiction will be in a federal court rather than a state court. Now, let me just give you one example. When when Lee Harvey Oswald assassinated President Kennedy, and my assumption is that he did, at the time there was no federal law which made it illegal to kill a president of the United States. Lee Harvey Oswald would have been tried in a Texas court because he had committed homicide or murder within the state of Texas. Since then, we have passed a federal law taking that into consideration, and it would now be a federal matter. But that's an example of jurisdiction. Now, there is another term which you will see in the newspapers or hear through the media, and that has to do with venue. And we'll put that on the screen for you. Venue. This simply means place, a place. In the court structure, it means the place of the trial. For example, a crime occurs within a court jurisdiction. It occurs within a city. There is a court there. The trial, the original jurisdiction is in that particular court. But there may be a problem. Perhaps there has been too much pre-trial publicity, and the defense attorney feels that his defendant cannot get a fair trial because he's not going to be able to get a jury that perhaps is unbiased and will only hear and judge on the evidence that is presented in court, not on what they've heard outside the court. There may be a motion for a change of venue, to move it to another court in another part of the state or another part of this county, something like that. It means a change of place of the trial. Now, there is a third item that I would like you to be aware of, and that is what we call the adversary system. The adversary system. Our court is, well, we use the term jurisprudence. Jurisprudence means philosophy of law. And one of the basic tenets of our philosophy of law and how we work with our courts or in our courts is we use the adversary system. This means that in criminal cases, each side is pitted against the other, the prosecution and the defense. And they present their evidence, and they are adversaries, one trying to prove guilt and one trying to prove innocence in a particular situation. Now the judge or the jury then acts as a neutral party, and they act as what is called a trier of fact. That is, they sit objectively listening to the two sides go at it, and then they decide based on what they've heard from the adversaries whether there has in fact been a crime committed and if the responsible or the accused is responsible for that crime. Now, in a jury, you have a constitutional right to have a jury. You may waive, that is, you may decide not to exercise that right to a jury trial. You have that right. You may waive that right and be heard only by the judge. In the situation where you have in the adversary system, you have the prosecution and the defense going at it, and you have a jury. The jury is the trier of fact. The judge then is the trier of law. He makes sure that all of the rules are observed. Where the jury trial is waived, then the judge will hear the evidence as a neutral party, and the judge then will act not only as the trier of fact, but also as the trier of law. He has a dual responsibility at that time. Now, there are other systems, for example, what is called the inquisitorial system. In some other countries, some Western European countries use what is called the inquisitorial system. Here, you have a judge or a panel of judges, and they become both the trier of fact and also the trier of law, but you don't have the adversary system. The judges or the judge will subpoena witnesses, they will question the witness, they will subpoena evidence, and they will do everything that in the adversary system is normally handled by the defense and the prosecution. Now, in the inquisitorial system, the attorneys act primarily as assistants to the judge. They assist in bringing their part of the court trial or court procedure into court, and they assist. But it is the judge or the panel of judges who really do everything. They ask the questions of the witnesses and so forth. So you have the inquisitorial, as an example. In the United States, we have the adversary system. Okay. Now, there is another principle that I would like you to think about and consider, and that is that our system, our criminal justice system, is an accusatorial system. We accuse. In our system, we accuse someone of a crime. Therefore, the someone who accuses another party of a crime, the burden of proof is on the accuser to prove that the accused did what the accuser said they did, and not that the accused must prove that they didn't necessarily. The burden of proof in our system is on the prosecution, not the defense. It is the assumption that everyone is proven innocent, is innocent until they are proven guilty. And in other systems, that's not necessarily the same way it happens. You are assumed guilty, and you have to prove yourself innocent. But the burden of proof in an accusatorial system is on the prosecution. If the prosecution cannot do this, then it assumes that the person is innocent. Now, in a very early, in fact, I think the first segment when we talked about corpus delicti and the essential elements of a crime, if you cannot prove, the prosecution cannot show the corpus delicti, then you do not have a prosecutable case, and it's a basic grounds for dismissal. All right. One other thing that I want to bring to your attention. In our system, we have protective checks throughout the judicial process to make sure, or to ensure as much as possible, that an innocent person isn't convicted. So the balance is weighted toward the innocent. That is, by golly, it is felt that we would rather let someone who is guilty go than put someone who is innocent in jail. It isn't a perfect system. I'm not saying that. But it certainly does, it helps to ensure. So our whole judicial system acts as a sieve. And there are gates and there are filters so that the innocent can be screened out, or where we believe there is some doubt, they can be screened out, and they are dropped out of the criminal justice system. And there is kind of a hierarchy of standards of proof that must be adhered to as you go through the criminal justice system. And they become more stringent the higher. They become tougher. The net gets tougher the higher that you go up. That down, very down in a low level of the criminal justice system, you can have a little doubt here and there, but by golly, when you get into trial, you have to have a much stronger case than when you started out. Let me explain this to you by going over here and showing you something of a little bit about what I mean. Now here we're talking about levels of proof and about how they become more stringent as you go through the criminal justice system. And these are really what we would call levels of proof. Now, for example, let's say that in an accusatory situation, we really have no significant proof of someone's guilt. Now, what do we really mean by this? Well, this means that, let's say that somebody has reported a crime, and that we have some some reason to believe that somebody has done a crime, has committed a crime, but we don't know exactly who. There is no significant proof to point to anyone. What action can be taken? Really none. This is really an investigative stage in which the police are investigating the merits of the crime to decide, to figure out if a crime has been committed, and if so, what kind of crime. Now, if we then, through investigation, we come to a reasonable basis of proof, this really means that we have belief that there is a significant possibility that a crime has been committed and that the accused may possibly have committed the crime. What action could be taken here? Well, at this level of proof, it's merely kind of a strong suspicion, and this, for example, an officer might stop someone on the street and ask them their name, do they live in the neighborhood, were they here on the premises at the time, blah, blah, blah. It's kind of that's about a low level of restraint, a very low level of restraint. There is certainly no arrest, but there is a suspicion that this person could be possibly the person who made it. Now, if we move down, we get stronger and stronger, and we talk about probable cause. Now, probable cause means that based on all of the evidence in the investigation, there is not a significant possibility, as we found here, but there is a substantial likelihood that the individual that we are thinking about or talking to has in fact committed the crime. And here you would find an arrest might take place. All right? So it gets tougher and tougher and tougher. There are more rules and regulations to screen out the innocent as we go. Now, if we go beyond that, let's say we've made an arrest, we get to a preponderance of evidence. And a preponderance really means more so than not. A preponderance means that based on all of the information, based on all of the evidence, it is more likely than not that a crime has been committed and this is the person who did it. Not just a significant possibility, not just substantial likelihood, but there is a lot going here. It's a lot more than a likelihood that a crime has been committed. Now, preponderance means more so than not. It means 51% versus 49, basically, is what we're talking about. Now, we usually find this in civil court. Civil court judgments are usually found on a preponderance of evidence. That is, yeah, we think more likely than not that this person did suffer damages. And the same rules of evidence and proof are not necessarily used in a criminal process because we drop down to prima facie evidence. If there's a Latin teacher who's viewing it, probably I should say prima facie. And if I'm still not saying it correctly, I apologize. In prima facie evidence, what we are saying is that we have a belief that is strong enough, based on the evidence brought to us by the prosecution only, that there is a reason to believe that a crime has been committed and that the accused did commit this crime. Now, in a moment, we'll talk about where this comes into play. This is usually what happens, or this is the kind of proof necessary. It is in what is called a preliminary hearing that usually precedes a felony trial. In a preliminary hearing, prima facie evidence is given to the court, and the court then decides whether or not a trial should be held, and that the accused should be held for that trial. All right? Now, that's certainly more than a significant belief. It's certainly more than substantial belief. And if we get down here, proof beyond a reasonable doubt. Proof beyond a reasonable doubt. Now, what this usually means is that we have such a belief, considering not just what the prosecution has given us on prima facie or prima facie evidence. But now we have gone into a trial, and based on both what the prosecution and the defense have brought into the court and presented as evidence, there is a belief that with all of this evidence presented, that it is a belief so strong that the person is clearly guilty of a crime, is absolutely clearly guilty, and it removes any reasonable doubt from the trier of fact, that is the jury or the judge. They are reasonably sure that this person, all reasonable doubt has been removed. And then when you reach this level of proof, this leads to a conviction. If you cannot, in the adversary system, prove it beyond a reasonable doubt, you probably will not have a conviction. If you do, it may be reversed on appeal. Now, I have put down absolute proof of guilt. Now, this is a belief that is so certain that the defendant is guilty as to eliminate even any reasonable doubt. There is no question. You can't say, well, 1 in a million. You remove even that possibility. But in most court trials, and in all court trials as a matter of fact, this is really not necessary. And usually it is usually never obtained. But as you can see, that through the judicial process, there are levels of proof that are necessary, and they act as protective checks for the individual who is accused of a crime or is being thought of as responsible for a crime. Now, with this in mind, and with jurisdiction and venue and these other things, let's now look at a basic court structure. All right? Now, if we look at a typical state, we find that there is a hierarchy of courts, that they have different jurisdictions, they handle different subject matter and so forth, and that they'll do a little different things along the way. And if we start at the bottom, we find that in many states at the lowest level, you will have a justice court or a justice of the peace, sometimes they are referred to in some states. And a justice court is the lowest court on the judicial rung. And what you usually find a justice of the peace or a justice court is in a rural area. And this is to provide some kind of court process that is accessible to people in a rural area. Now, justice courts are normally restricted in the subject matter jurisdiction. They will normally hear only misdemeanors. And remember, we said that misdemeanors are usually your lowest in severity kinds of crimes, trespass and this sort of thing. They'll hear civil cases, yes, they'll hear some civil cases. Justice of the peace, for example, can handle civil situations, for example, marrying people and other civil obligations and subject matter. But in the criminal area, they will normally handle only misdemeanors, and usually misdemeanors of a very low level. Usually, let's say that if the punishment for a misdemeanor is up to 1 year in jail, in the county jail, that some misdemeanors will call for up to only 6 months. Well, maybe only those cases will be handled by a justice court. It is a way of providing immediate or accessible judicial personnel to people in a non-populous area. I ran into a situation in a rural area in a state that I used to live in where there was a justice of the peace in the north end or the far end of the county, and many times a deputy sheriff would make an arrest, and the man would say, I want to be brought before the judge immediately. And at 11, 12 o'clock at night, the deputy would drive up to this justice court, the justice judge, to his home, and the justice court judge would come out of his home in his flannel robe and his slippers, and he would hold court over at the front end of the patrol car, at the hood ornament, with the deputy on one fender and the defendant on the other, and he'd say, "What did old Fred do here?" And, "Well, old Fred did this, that, and the other thing." "Did you do it, Fred?" "Yes, Your Honor." "$15. I only have 10, and he'd tell the deputy to loan him 5 because he knows he's good for it, and that would take care of it. That's the way it would work. Now, in many areas, it is still that way. In other areas, it's a little more sophisticated. Now, if we move up the line here, we run into municipal or district courts sometimes. In many states, the names will vary. But you will usually find a municipal court or a district court in a more populous area. There is more business, therefore, and they will handle, their jurisdiction will also be civil or tort as well as criminal. But again, here usually the majority of the work that is performed by these judges is for misdemeanors. And they will handle usually all misdemeanors. Now, they also have another function in that if there is a felony that occurs, a felony being a much more serious crime. Now, a felony is a very expensive proposition when you go into a trial. It can go on for weeks and weeks and weeks and cost a lot of money, and is a very serious matter, and it needs some kind of judicial review. And it is here that usually a person who is accused of a felony will appear first in a district or a municipal court, and they will plead, that is, they will have their arraignment and hear the charges, and then there usually will be what is called a preliminary hearing, in which the prosecution will, as I said before, present the prima facie evidence that the accused did commit a crime. The judge, if he agrees with this, then will bind it over to a higher court, which is the court with the jurisdiction as the trial court. Now, I hope that makes sense to you in many ways. All right, these two courts, the justice and the municipal court, are usually referred to as inferior courts. That doesn't mean that they're really not, it doesn't mean that they're bad. It means that they are usually handling subject matter that is perhaps of a less severity than some of the other courts. It doesn't mean that they work any less, because they work very hard, because the bulk of the cases will come through these courts right here, the inferior courts. They handle most of the initial action. Now, usually here you will find that a judge has a great deal of latitude in sentencing. It's here that in most states probation is usually a county function. In some states it is a state function, but the judge may place the person on probation. He may fine them. He may send them to a term in the county jail. He may suspend the sentence, that is, say, I'm not going to do anything this time, but if you come before me again and are convicted, I will impose not only the new sentence, but the old sentence as well. And they also may use what is called restitution. That is, if the victim has suffered some loss, pay for personal injury, hospital bills, and so forth, that may be part of the sentencing. This, they may call them inferior, but they earn their money. They do a lot of work. Now, above this, we have what is called in some states a superior court or a circuit court. And here, again, you have a demarcation between civil and criminal. On the civil portion, these courts will usually hear probate, that is, wills and that sort of thing. They will hear divorce cases, custody cases, and so forth. That's their subject matter jurisdiction, and not necessarily that of the inferior court. But it is also in the civil side that you will find juvenile court. Juvenile court is a civil court in almost every state that I know of, unless it's changed since the last time I looked at a book. You will find it, juveniles are treated as in a civil section and not as a criminal, not in the criminal courts ordinarily. The original jurisdiction for a juvenile under such and such an age is with a civil superior court, circuit court. They may choose to change the venue into a criminal court, but it is their choice. Now, it is this level that you have a trial court, and it is this level where felony trials are held in most states. And in some situations, the superior court may also act as an appellate court from the inferior court. In some situations, a person here may be found guilty. They say, now look, I don't think this is quite right. They may file an appeal. It may sometimes, in some states, go to a superior court, and they will review and decide whether it should go to a higher appellate court or if it should be returned. This is not necessarily true of all states, however. Now, you have the right to appeal. If you find that you have been found guilty and you feel that some error has taken place, that you're innocent, you have the constitutional right to appeal. And you then will appeal to a higher court. You will appeal above the superior court to courts which have the jurisdiction to hear appeals, the subject matter jurisdiction. And you usually will have a state appellate court in which superior courts from all over the states will be, appeals from lower courts will be funneled in, and they will hear these appeals, and they will render some kind of decision. That is, they may affirm the case, the judgment, and say, yes, you were given a fair trial and you are guilty, and the sentence may be carried out. On the other hand, they may vacate the sentence, or they may say that the trial was handled improperly, and they may dismiss the whole rascally thing. The prosecution then has the option to decide whether they want to start a second trial or not. Sometimes they will have second, third, and fourth trials because of appeals. Now, if the appellate court still decides that you are guilty, you still have the recourse to go to a state supreme court and find out whether or not they will hear the case, and if they hear the case, whether they will render a judgment for you or against you. If they will uphold your motion and your appeal that you have been unjustly maligned and convicted and so forth. And this is basically how most court systems are set up. You may have special courts in some states with special names. You may have a domestic court, for example. You may have some other kinds of courts. But this is basically and essentially the court structure of most states. And I hope that you followed me so far. And because there's another thing. Remember I was talking about that you have dual citizenship, that you come under federal as well as state laws, and you can go also through the federal system. Now the federal system looks a little like this. And this is a kind of a plot map that West Publishing Company puts out. What we have here basically is a map that tells you the different courts in the federal system. It looks rather complicated, but we'll simplify it a great deal. There are courts for example, special courts for U.S. possessions and territories, Guam and wherever you are. You have government agencies which can act as fact finders and hold hearings and have violations of federal regulations and so forth, and they can be channeled into the court system. Basically, this is what we're talking about here. It's really a much simpler kind of situation than what appears here. Because basically, instead of having 3 trial courts in the U.S. system, you only have one, and you'll have a U.S. district court, which will be the one trial court. It will handle civil cases, but it will also handle criminal cases. And from that one court, you will then go up to a federal appellate court, and very much like the state appellate court, and these appeals will be funneled in from, let's say, a region rather than a region of America rather than a region from the state. It may be, 3 or 4 states will funnel their appeals to a federal appellate court, and then eventually, if that does not work, then you go up to the U.S. Supreme Court. The U.S. Supreme Court has the option of whether they will hear your case or not. They can choose not to hear it and deny you a hearing. They get thousands of appeals every year. Obviously, there is not enough time to do this kind of thing, and they have the choice of picking and choosing the ones that they want to hear. All right, that looks a little complicated, perhaps, but it really is not. The federal system is. We could spend a whole year on it, but basically it's just those three levels. One trial court, one appellate court, lower appellate court, and then the U.S. Supreme Court. Now, let me show you very quickly how this thing can kind of work here. Let's say, and to illustrate what we were talking about dual citizenship, let's say that you have been found guilty of a felony, in a superior or a circuit court judge, by a judge here, and you're very unhappy about this, and you feel that there have been errors committed in this trial which prejudiced the jury, perhaps. The judge, beneath his robes, was wearing a tie, and he took out his tie, and he's making hanging motions toward the jury, which perhaps is influencing them somehow. And you felt that under the U.S. Constitution and also under the state criminal justice procedure codes that you really did not get a fair trial here. They didn't listen to the evidence. They were more or less looking at the judge. Now, you got a little bit of a problem, so you file an appeal. You file an appeal, and it goes here. And then it goes up to here. And let's say it was denied, that this appellate court denied it, the state Supreme Court denied it, and then you say, now, wait a minute. What's happened here is that under the U.S. Constitution, I have the right to a fair trial. And I was denied that right. What you then do is you file a motion over here. And then you make your same, based on the fact that they have denied you a fair trial, and now you're talking about your constitutional rights. So you move over here. If they turn it down, you go up to the U.S. Supreme Court. Now, the reason I tell you this is because it depends on what we're doing at any given time. Capital punishment comes in and out depending upon the mood of society. But where you have had, for example, people who have been on death row for 10 years or more, this is what happens. They will not file all their appeals at one time. Let's say there are 10 points that they feel that they can file an appeal on. The jury shook dice, and that's how they came to a verdict. The jury was drunk. The stenographer was making rude gestures, whatever it might be. Instead of filing all 10 at once, you only file one. You file your first one, and it goes here, and it goes here, and it goes here, and it goes here, and it's denied. Then you bring out number 2, and it goes through the whole process, and number 3, and so forth. Now, as this whole process, time is consumed. It takes months, maybe even years for this whole process to occur. I'm trying to figure out if this is starting to look more like a Salvador Dali or something from an Italian restaurant. I'm not quite sure. But that's how it works. So that over a period of time, let's say that each appeal takes a year and you've got 10 appeals, you're going to be on death row for 10 years. And if you're really smart, if you've got a smart attorney, if he can't find anything wrong, he'll build something in, because that will give him an appeal which will stay your the execution date or the sentence date, so that he can figure out something else to do for you. All right? So that's how it works. A little confusing, isn't it? Well, I wouldn't worry about it. Now, there are other things we have to move on to here. Now, in this ball game that I've been talking about over here on the board, obviously there are players. And let's get a kind of a fast rundown on the players in the court system. Obviously, first of all, we have the victim. Now, victims have really a hard time understanding the adversary system. In civil court, it's Kramer versus Kramer. It's Jones versus Blatz. It's so-and-so versus so-and-so. But when you go into a criminal case, it is the state of, or the commonwealth of, versus so-and-so. Now this makes the defendant feel a little anxious, perhaps. The whole state is against me. But it also makes the victim feel a little strange. I am the person that has been harmed here, and now I'm merely a player. I have a role to play. And it's very difficult sometimes for victims to understand that it is the state that is doing the prosecution, and it is the state that is going to handle their affair for them, and their role is merely as a player on this particular stage. Sometimes it's a little hard for the victim to understand this. And as I say, I'm the victim, blah, blah, blah. For the defendant, it can be a little perilous too. The awesome power of the state of such and such is going to go out and get you. And they say, well, gee, if it was just between the victim and I, we can handle this out in an alley. But the weight now of the state is upon me. And that is a little terrifying if you've never been a defendant before also. For some people, you've been defended more than once, and it doesn't come as any new news. Now, for police officers have a difficult time in court. And I'll tell you why, particularly when they're new. Okay? When they're new, just like the victim for the first time coming into court, or the defendant for the first time coming into court, for the police officer coming into court, it can be a little strange experience, and sometimes a little unnerving. Particularly if you've gone by the name of Macho Jones, and everyone knows you as Macho Jones, and when you have to get up and swear, and they say, give your full name, and it comes out Petunia Llewellyn Fergus Jones, and everybody goes, that sort of thing, and now everybody in the world knows that it's not Macho. Little things like that. You think I'm being facetious, but little things like that, the first time can bother people. And it can bother police officers. And they can turn into kind of like robots because of it. On routine patrol, I was doing the talk on a monotone, and that sort of thing. What is particularly hard for an officer to understand is that he's been out on the street, and he's dealing with an emotional problem, and he's really got a tough thing here, and he has to put a lid on it so it won't get any worse. And he goes out and he does, in his judgment, what he thinks is the best thing, and he gets that case, and under those rules, in that ball game, he's done a good job. But when he moves into the courts, he's in an entirely different ballpark, playing an entirely different game. And it's a game. It's a game of concepts and words. And there may be emotion involved in it too, but it's completely different from being out on the street. And the defendant that was kicking him and punching him and abusive and all this sort of thing is now sitting there in a three-piece suit with a haircut, and he's shaved and he's all shined up and he looks like a choir boy. And the police officer says, I wish you would have seen this guy, and seen him when he was drunk, and seen this and seen that, and the jury can't see that, and so forth. And this is sometimes a little bit of a problem for police officers. And for some officers, it's such a problem to deal with, there is the urge, and sometimes they will pad their testimony, which reduces their credibility and completely blows the believableness of their testimony in front of many judges, and if they catch him at it, they can prosecute him for perjury too. So you've got some problems there. Now, we have the prosecutors. Now, the prosecutors have a problem. Now, you have a lot of professional prosecutors, district attorneys and assistant district attorneys. And you've got a lot of good ones, And they decided to make this a career, and it's really super. Now, what the problem occurs here is that generally in law, criminal law is probably the least best paying part of being an attorney. If you really want to make money, you go into corporate law or something else. So not too many people are attracted to criminal law. And you have a lot, and usually salaries when you're working for a county and that sort of thing are not really all that great, or let's say it's relative. They're not as good as it could be. So what happens is you've got a lot of people that are in there because they really feel it's important and they're doing a good job, but they're always under strength. So they have to fill the ranks with somebody just out of law school. And somebody just out of law school decides this is a good job because I've got a salary, and I don't have to be the 16th member of a law firm, and I've got a steady salary, and I'm getting terrific experience. So you've got somebody who's fresh out of law school who does not have much trial experience. And they have to perhaps go into a courtroom up against an attorney who's had 30 years and knows what's going on in the adversary situation. And this puts the young district attorney at a disadvantage sometimes. It certainly helps to protect the defendant, but sometimes it doesn't always help to protect society or the victim. And here you got a little bit of a problem. I'm not saying that this is general. I'm saying this occurs sometimes. Sometimes. And they have a very difficult job, the prosecuting attorney. They're usually understaffed. If you have district courts, municipal courts all over a county, maybe this particular court only meets on Tuesdays, and maybe this one on Wednesdays, and they're traveling 60 miles to be here in the morning and 60 miles to be over there in some other place in the afternoon, and they've got their cases, and maybe they have so many cases they haven't had really a time to even read them. And they're waiting for the officer who is the arresting officer in the hallway, and he pulls out his brief on the case and says, is there anything you got to tell me that isn't in here? And the officer says, no, it's all in the report. And he sits down, and as they call the first witness, he opens it up and reads it and has to figure out what he's going to have to say. Now that's a very difficult situation. Now on the defendant's side, you have a little different kind of situation. In the free enterprise system, you can hire an attorney. Money buys brains. If you have a lot of money, you can buy a lot of brains. If you don't have much money, well, you're going to have to negotiate and make the best deal you can. We do have public defenders in many states. These are county employees like the district attorney. They are paid and they handle the cases of people who cannot afford an attorney. You also have the Bar Association will set up a list of all of the attorneys in a particular area, and they will volunteer their services to people who are indigent or cannot afford the normal attorney fee. And the judge, if this is the case, the judge will appoint from that list an attorney who will come in and defend the accused. So it's a very, very complicated situation. Then we get to witnesses. And witnesses have a difficult time too. They're there. They're not too sure if they want to be there many times. They sit down in the seat and they're sworn in and they're looking at the defendant, and they may be afraid the defendant is going to, take this unkindly if they're testifying against them, and the defendant is going to come and get them maybe. They're terrified by perhaps what's going on. This isn't always the case. Sometimes they'll get up and they're just, like they're professionals. They've been doing it forever. One problem with witnesses is that you have people who, you have rules on what you can say. I ask a question of a witness and I want a yes or no answer, and the witness says, but yeah, let me qualify that. Let me tell you the whole story. And they say, we don't want it. All we want are a yes or no. This becomes very frustrating. Very frustrating. Sometimes it's very difficult for witnesses, not only the layman, but also the expert. You will have experts who will come in and testify on technological things, perhaps, that are above and beyond the normal layman's knowledge. Now the jury. Now the jury is a very complex thing, and there's really a science to selecting a jury. There's a very old adage that if you're guilty as heck, don't ask for a jury trial, because the jury can become confused and they'll let you off. If you're innocent, on the other hand, waive the jury, have a trial by the judge, because he knows what the law is and he won't become as confused, and he'll probably make sure you get off. There's a very old adage like that. All right, now, into the adversary system when the two sides select the jury. Obviously the prosecution wants people who are going to favor them and so forth. The defense is going to want people that will be probably sympathetic to the defendant. If you have a drunk driving case, for example, you would love to have a bunch of roaring alcoholics who would say, gee, I've had more to drink than that and driven home and had no problem. That poor fellow is obviously not guilty. That sort of thing. And there's a process to selecting a jury. A jury, the average layman, does not understand the complexities of law. Sometimes they don't understand a word of what the expert witnesses are saying. You get into situations where the sanity is an issue, and you bring in 3 psychiatrists for the defense and 3 psychiatrists for the prosecution. And here are 6 experts, but 3 are saying one thing, 3 are saying the other, and the jury becomes thoroughly confused. So you got a real problem there. And there have been studies, for example, where they have given people information. They said, you're going to be on a jury, and here's the information about the whole case, and here's a picture of the defendant. And what they've done is they've changed the picture of the defendants. And one possible jury would convict the rascal on the same information, while another possible jury would not convict him because of the picture. There are all kinds of things that happen in court. It's really interesting. It's really, really interesting to watch. Obviously, one of the most important places, and this is a very complicated area. They have a very complicated job to do. They have to act sometimes as not only the trier of fact, but also the trier of law. And if they decide if a person is guilty or not, they must also then decide what the proper sentence will be. In serious cases, such as felonies, they may have not much to go on. The state says you'll just turn them over to the prisons, and the prison and the parole board will figure out what's going on. Down at the lower level, where we're talking about probation, the judge has to think what is best for the individual, what is best for society. Is a fine the best? Is probation? Is a jail term? Restitution? All these other things. What is best? He's got the scales to weigh here. And that can be really a difficult problem for a judge. It's a very complicated job. Very complicated job. Now, all of these players play very special roles. Very special roles. And sometimes it's confusing about what these roles are for the layman. And I would suggest that sometime, if you have the opportunity, you go in and you sit in on a case and just watch and see what's happening and find somebody and ask questions. Why did you, if you can grab an attorney, why did you do this and why did you do that? Why, what happened here? You can read about it, you can get books from the library certainly, but you can also go and actually see trials if you've never seen one before. All right, now what are the problems of the courts quite quickly? Well, they're tremendous, absolutely tremendous. There are lots of pluses, there are lots of minuses, unfortunately, when you look at the courts. Society has changed. We have a better informed people who are better informed of their rights. We exercise and protect the rights of individuals more and more. So as crime goes up, there's more work, but also the trials themselves become more complicated. So it's not just volume that is clogging the courts, it's also the complexity of the trials that are a problem. It just overloads the courts. When we have to be very careful about trials, they're very costly. You can get murder trials that can occur in a small rural area, and it can run into the millions of dollars, and it can bankrupt a county. It can consume a major part of the county budget. You have to be very, very, very careful. The public is one of the problems of the courts are very critical. The public is very critical of the courts. And the courts are caught in the middle between protecting society and protecting the individual. It is not an easy issue to resolve. Sentencing, as we say, is a problem. The judge sentences someone and he says, my gosh, you're going to go to prison, and I know if I send him to prison it isn't going to do him any good. He'll probably come out worse than he was. About the only thing I can say is at least he'll be out of circulation. But when he comes back, look out. Because if I send him to prison, that's one thing, or I send him to the county jail. If I'm in, because maybe I don't have any other resources. Maybe I'm in a small county, and maybe there are not enough agencies that will help, or enough volunteers that will help. That is a big and a very difficult part of the court problems today. The other parts of the criminal justice system get upset with the courts. The police get upset with the courts. Probation may get upset with the courts. And they have community relation problems. Now, the courts also are uneven. There are states that have made gigantic strides to come to make them better. And other states have not. Even in the states that have made giant strides to modernize the court system, you've still got some judges for some reason who are